This is English Shorthand Dictation number 340, and the dictation speed is 120 words per minute. Ready? Start. The present respondents filed an application under Article 227 of the Constitution of India 1950 before the Orissa High Court. By the impugned judgment, the High Court held that the decision of the authorities rejecting the prayer for compassionate appointment was not in order. Direction was given to appoint the present respondent number 2 within a particular time with the condition that respondent number 2 will financially support respondent number 1 so long as she is alive. The learned Additional Solicitor General submitted that the findings recorded by the High Court are erroneous. The rejection of the claim for compassionate appointment was done after considering the report made by the concerned authority, which conducted due and proper inquiry about the financial status. CAT considered the relevant aspects and rightly held that the prayer for compassionate appointment was not to be accepted. The High Court erroneously placed emphasis on the certificate issued by the Member of Parliament and directed for appointment. Such a direction could not have been given. At the most, the High Court could have directed for consideration of the caste of respondent number 2 along with similarly placed persons. In any event, no evidence was led to show that the findings recorded by the inquiring authority were erroneous. In response, the learned counsel appearing for the respondents submitted that the scheme of the authorities clearly indicates that if a certificate is issued by a sarpanch or a member of parliament or a member of legislative assembly, then the request for compassionate appointment may be entertained and considered on merits. In this case, undisputedly, a member of parliament had given a certificate which was not shown to be wrong. We find that it has been clearly indicated in the report about sufficient income of all members of the family and the prima facie absence of any material to show that the members had separated. The respondents remained content by producing certificate of member of parliament. No other material was placed for consideration to contradict conclusions recorded in the inquiry report. Great emphasis has been laid by the respondents on the scheme of compassionate appointment, more particularly in cases where there is already an earning member in the family. But if Sarpanch, MP, or MLA certified that the employed member is living separately and not referring any financial assistance to the main family, the requests of compassionate appointment may be entertained and considered on merits. The same is not of any assistance to the respondents. The quoted portion was one of the points on which clarification was sought for. In any event, there was not even a remote suggestion that the certificate of MP or MLA would be determinative. It would be therefore appropriate to direct the tribunal not, to consider the matter. The parties shall be permitted to place materials in support of their respective stand. It goes without saying that CAT, after considering the relevant materials, shall dispose of the matter in accordance with law. We make it clear that we have not expressed any opinion on the merits of the case. However, the High Court was clearly in error in directing appointment without reference to the presence of similarly situated persons who were seeking compassionate appointment. No direction could have been given by the High Court for appointment as such within a time limit and for asking extension of time to comply with the order till the concerned respondent was appointed. At the most, the High Court could have asked for consideration of the case of the concerned respondent along with other applicants for compassionate appointment, if any. In terms of the operative scheme, the appeal is accordingly disposed of. In the present case, the appellant is a Saini declared as the other backward class in the state of Haryana notification dated 5 to 1991. This notification, inter alia, provides that persons belonging to the Saini caste and residing in the state of Haryana will be considered as forming a part of other backward classes in the state of Haryana. Two advertisements bearing number 1 of 1995 and number 7 of 1995 were issued by the Subordinate Service Selection Board, Haryana, for recruitment of candidates to various posts. One of the posts so advertised was that of lecturers in political science. Under advertisement number 1 of 1995, 15 posts of lecturers in political science were advertised, of which one was reserved for backward classes. Under advertisement number 7 of 1995, inter alia, 48 posts of lecturers in political science were advertised, out of which 10 were reserved for backward classes. Out of these 10, 6 were reserved for backward classes in the A category and 4 were reserved for backward classes in the B category. After the advertisement number 1 of 1995 and before advertisement number 7 of 1995, instructions were issued by the Chief Secretary, Government of Haryana, to all heads of departments and other authorities, stating that the reservation for backward classes was enhanced from 10% to 27%, and that amongst backward classes it was decided to create two blocks, Block A and Block B. Instructions were also issued by the Chief Secretary, Government of Haryana, that 16% of seats would be reserved for backward classes in Block A and 11% would be reserved for backward classes in Block B. There was also a reservation of 10% for ex servicemen and 3% for physically handicapped. Castes forming Part B of Block A and castes forming part of Block B were enumerated. Saini caste was in Block B. That is why the advertisement number 7 of 1995 divided the 10 seats for backward classes into 6 seats for backward class candidates in Block A and 4 seats for backward class candidates in Block B. After these instructions, therefore, the appellant formed a part of Block B amongst backward classes. The appellant applied for the post of lecturer in political science.